Good afternoon. Happy Friday. I had a lot of questions about fighting words yesterday from various people. I was sent a video about a case, Willson versus the blah, blah, blah District Court of Nevada. It's a Nevada appellate court case that dealt with NRS 197. Yeah, NRS 187 dot whatever. It was one of the two charges that Chile was charged with, delaying, obstructing, or hindering an officer in the performance of his duty. The video that I was sent was from a gentleman who goes by the name of Here's the Deal on YouTube, a sovereign citizen with little to no understanding of the law, who, when I saw him a day or two ago on Chile de Castro's channel, filling in for Chile, he was talking to Artie, and he is under the impression that states cannot require registration of vehicles and licenses, etc., which, yeah, they can. I mean, this is one of those perennial kinds of issues that just never dies, because somebody somewhere will get their ticket dismissed or case dismissed for whatever reason, and all of a sudden, it validates the whole shebang, whether they have proof of it or not. It validates the whole shebang, and all of a sudden, everybody's, oh, see, we could drive without a license. See, we could drive without registering our vehicles. Blah blah blah. The problem is that every court of appeals that has ever addressed this issue has resoundingly decided that there is no constitutional prohibition, nor is there any federal prohibition against a state requiring licenses for vehicles operated on public roadways and registration for vehicles operated on public roadways. It's part of the policing power of the state. Any powers that aren't granted to the federal government are reserved to the people and to the states. Well, this is the part of the police power of the states. So he's a moron, and he costs people money because there are dumb people who are going to listen to him, and he tries to couch it in a way where he's not actually giving legal advice, but he is. Like, you'd have to be dumb to think that he's not telling people what they want to hear in order to get the clicks and views, and leave a comment in the comment section on how you think this should be decided. So he's a moron. Well, he plays a moron on TV. I have a hunch, a sneaking suspicion that he probably makes enough money on YouTube that he doesn't risk it by failing to register his vehicles and by failing to have a license when he operates a vehicle on a public roadway. I'm going to guess that he uses Federal Reserve notes and acts just like an ordinary citizen, but he talks the game on his channel to convince suckers to give him views and likes and subscriptions and whatever else, donate to his PayPal, yada, yada, blah, blah, blah. Which leads me to my next point. My next point is still entirely unrelated to the actual thrust of this video, but people will say and do things for money. If you ever wonder why I don't, it's because I don't do this for money. You're getting my actual opinion. I don't give a shit about viewers or comments or anything like that, other than whatever pleasure I can take out of it, because I don't get paid to do it. So, if I don't get pleasure out of your comments, I have no incentive to not hide you from the channel, because I don't give a fuck. I don't gain anything by having to deal with idiots. I gain nothing by it. When I get good comments, sure, I'm happy to look into things and make videos on it, especially if it's an interesting comment. If it's interesting to me, not to you, to me. Colin, whatever the hell, from Project Constitution. Yeah, I'll look at my videos. Look at my case against Chile. No, it's not interesting. You're not interesting. I'm not interested. I only do the things that interest me. Sorry, not sorry. But people do things for money. which leads me to Chili's attorneys, I guess. Me is still his attorney in his civil suit, and Orem is his attorney on the appeal. And Orem is going to argue that he has a First Amendment argument. He's going to do that because Chili's paying him. If he was getting paid to give an actual opinion on whether or not there was a First Amendment claim there, I'm sure you would get a different result. But he's not getting paid to give his opinion. He's getting paid to argue a position. And he's going to argue a position. I get paid to argue a position. Unlike a lot of attorneys, I like my clients to have an informed decision on it. So I will say to my clients, like I had a case just recently where my client, she married a sex offender, a registered sex offender. And her baby daddy found out that she's now living with a registered sex offender and moved to get full custody of the child. And California laws are pretty clear that, there's a huge presumption. You've got a huge hurdle to leap in order to even justify having a kid around a registered sex offender, let alone, living with him. I mean, it's good luck. And she came to me and I said, hey, these are the arguments I can make. Your odds of success are fairly low. We're behind the 8 ball. They have all the cards. Really, they would have to screw up really bad. And the judge would really have to not like baby daddy and really like you and really like your registered sex offender husband in order for even to have a shot. And she's like, well, I still want to go for it. Okay, I'll take your money. You've been informed. Let's go. Right? But a lot of attorneys won't. I mean, I literally work with attorneys who will be like, oh, you've got a great case. Let's go. Pay me $5,000 retainer and, I'm off to the races for you. Yeah. I'm sure Orem, I've heard that he had a $25,000 retainer. Yeah, you pay an attorney $25,000, he'll argue whatever you want him to argue. I mean, generally speaking. And if you can't find someone who will argue what you want them to argue, you haven't looked hard enough, because not every attorney out there is ethical, I assure you. And if you needed me to assure you of that, well, what rock did you just crawl out from under? Anyway, which leads me towards the actual point of the video. The point of the video, of this video, was that in Here's the Deals video, he was going over a case, Willson versus whatever District Court of Nevada, the Nevada Court of Appeals case. Now, if you look up that particular statute, NRS 197. whatever, if you look it up in Google Scholar, that is literally the only case that'll come up. So have I seen it? Absolutely, I've seen it. The reason why I never mentioned it prior to this is because it's not applicable. In my comment section that I did on Chili's possible grounds for appeal, this case was raised by many commenters. It's been around for a while. I've known of it for a while, and I haven't brought it up. Why haven't I brought it up? Because it's inapplicable. How do you know it's inapplicable, John? Well, because I can read. So when you read it, the court makes the rather unsurprising decision that the statute applies to fighting words and physical conduct. So either the state has to prove that your words were fighting words, and you willfully use these fighting words to hinder, obstruct, or delay the officers, or they'd have to prove that you willfully did actions that hindered, obstructed, or delayed the officers. They don't have to necessarily prove your intent is to hinder, obstruct, or delay the officers. They have to prove that you intended to do the action that ended up hindering, obstructing, or delaying the officers. It's bonus points if they can show you willfully intended to achieve the result of hindering, obstruction, or delay. I hope that makes sense. Now, let's stop and look at what Chili was charged with. What happened in the video? He walks up and he inserts himself into the crime scene, and the officer tells him, "Get back." Now, people are going to say, well, Chili did get back. Great. But did he get back to the point where he stopped hindering, obstructing, or delaying the officer? Was he still being put on notice by the officer that he was hindering, obstructing, and delaying the officer? He did not move back far enough to stop hindering, obstructing, or delaying the officer. And the officer kept him very well informed that you are still hindering, obstructing, and delaying me because I'm still telling you to move back. Now, it's not whether or not he moved back. That's not the thing. He's not being charged with failing to move back. Some people are also saying that the order telling Chili to move back wasn't a lawful order. Well, whether it was or wasn't, I don't even have to address that. Again, he's not charged with failing to obey a lawful order. He's charged with willfully hindering, obstructing, or delaying the officer. So they have to prove two things, basically. Number one, that his actions were willful, that he intended to do them. And number two, that those actions, the result of those actions was the officer was hindered, obstructed, or delayed. Was the officer hindered, obstructed, or delayed? It appears to be so. The video shows him dealing with Chili instead of dealing with the driver. That prima facie evidence that he was hindered, obstructed, or delayed. Was it willful? Well, they established it was willful in court because the officer kept telling Chili, you're interfering with my traffic stop. You need to back up. You need to back up. You need to back up. That's the officer saying, you're obstructing, delaying, or hindering me. And at trial, I mean, people are like, oh, the officer lied on the stand. The officer said Chili didn't back up, but Chili did back up because here's this picture that shows that Chili backed up 2 feet or 3 feet. That's not a material thing. If a question is so unclear and an answer is so unclear, then it would be the responsibility of the attorney to continue to ask questions to clarify. So, did Chili back up? Yes. And if the other attorney comes back and says, did Chili back up? And the officer says no, it would be, well, you said no before, why are you giving two different answers? Oh, well, I thought you meant on the first one, did he back up to the point where I wanted him to back up? And on the second one, I thought you meant whatever, right? So, but the court is the ultimate determiner of who did or didn't lie on the stand, because the court, in this case, it's bench trial, the court's the finder of fact, and the court didn't find that he lied. The court chose to believe him, and the Court of Appeals is going to choose to believe the judge, or to believe the officer as well. It's too late to impeach him. It would have been incumbent on me, the attorney, not me, but the attorney, Michael Me. It would have been incumbent on him, the defense attorney, to really establish that the officer was lying to try to attack his credibility. So, day late, dollar short on that. And again, if the attorney asks, did he back up? And the officer replies, no. And then another attorney asks, did he back up 2 feet? And he goes, yes. Or did he take a step back? And the officer goes, yes. Are those two things contradictory? No, because it depends on what the intent of the answer is. Did he back up? No, he didn't back up as far as I wanted him to back up. When you're attorney, I guess you kind of focus more on sloppy questions and sloppy answers. If you go into my Discord, Rogue Nation is always in there asking the world's sloppiest fucking questions and expecting a yes or no answer. And today it was, can cops trespass you from a park if you're just eating lunch with your family, just eating a picnic with your family? And he wanted a yes or no answer on that. Obviously, there's a lot of factors in there. Is it a public park? Is it a private park? Is there paid admission? Is there free admission? There's so many questions that you would have to ask in order to clarify so that you would know how to respond to it. Sloppy questions. And at trial, you're going to get sloppy questions because you're thinking of these things basically on the fly. You're trying to, these are the questions that were asked by the state. Now you're going to come in and you're going to try to ask clarifying, distinguishing, whatever questions. You probably don't have them prepared ahead of time because you don't know what the state's going to ask him and you don't know what his answers are going to be. So you go in there and you basically have to think of a lot of these things on the fly. You got a million things going through your head at trial. So I'm not saying that me did a bad job. I'm saying that if that was a tact that me wanted to go down, but me probably also understood the answers that the cop gave, that they weren't lying, yada yada. So it would have been a bad tact for me to go down because the body cam video showed that Chili stayed in the same general area despite being told to back up. And taking one step back, especially in a fluid situation where people are moving, it is neither what the officer would have interpreted as backing up, nor would it be what the state would be asking about, nor would it be relevant to the judge. Because again, the judge doesn't really fucking care if you backed up 3 feet. The judge cares, is he intentionally hindering, obstructing, and delaying the officer? That's what's in front of the judge. So how far he backed up, immaterial. Whether the order was lawful or not, immaterial. Were Chili's actions willful? And did those actions end up hindering, obstructing, or delaying the officer? That's what the court's looking at. So let's go on to this Willson case. The case that, here's the deal, breathlessly read with a turgid boner, thinking that somehow this case has anything to do with what happened to Chili. If you look at the facts in Willson were that Willson was in her yard. No officer ever took exception either at the scene or at trial with the location of Willson. Willson was not informed that she needed to back up. What the officers were complaining about were the words that she was saying, and the officers were telling her to shut up. Maybe not in those specific terms, but they were telling her to shut up. It is clear from that it is not her location that is at issue. It's not her actions that are at issue. It was her speech that was at issue, because that's what the officers addressed at the scene, and that's what the officers testified about in court, and that's what she was convicted based on. Speech. Chili was not told to shut up. Chili was told to back up. Chili was not in his yard. Chili's location was the issue. Chili said, I have a right to film. The officer said, I don't care if you film from over there, in not so many words. There are two different cases that deal with two different things. The outcome of Willson is not relevant to Chili's case at all, but the outcome was that the only things that can satisfy the elements of the statute, hinder, obstruct, and delay, are physical acts and fighting words. Or fighting words. So you can violate the statute just through purely physical acts, or you could violate the statute if the words that you use are fighting words. Can't just be loud. Can't just be obnoxious. They have to be fighting words. Now, a longtime viewer disappointed me very massively yesterday. I was a bit heartbroken because I like this person in an internet kind of way. And this person asked me, what are fighting words? And I thought to myself, oh my God. How many videos have I made talking about breach of peace statutes, disturbing the peace statutes, disorderly conduct statutes? How many of these statutes have I gone down over the years from various jurisdictions where I have explained that in order to not be overbroad, a statute that criminalizes behavior along those lines, if it does target speech, it has to target unprotected speech. So it could be a true threat. It could be fighting words. It could be, I don't know, material depicting children in unfortunate situations. It has to be unprotected speech. If one of those statutes is going to target speech, it has to be unprotected speech, or else the statute itself would be overbroad. It would, by being overbroad, that means it would essentially try to criminalize First Amendment protected speech. Okay? Now, what are fighting words? As I've explained many times in the past, fighting words are any words or any combination of words that, in light of the circumstances they are spoken in, would tend to incite an immediate breach of the peace. It's got to be an immediate breach of the peace. It has to tend to incite an immediate breach of the peace. I.e., if you said this to someone in those circumstances where you said it, there is a reasonable probability that a person would pop you in the mouth for saying words like that. For example, a common example I give is if you drop a hard R at a Klan rally, no one will probably care. Everybody will be like, yeah, hard R, hard R, hard R. If you drop a hard R at a rap concert, there will probably be somebody swinging a fist at your face really quick. Or, for those of you who haven't understood videos from over the last few days, if you whisper softly into your wife's ear, I'm going to make sweet, sweet love. I'm going to tear that ass up tonight. Probably not fighting words. Depending on your wife and the mood she's in, granted, probably not fighting words. If you say those same things, if you whisper those same words into the ear of your celly, probably fighting words. Again, depending on your celly and their particular mood. Maybe it's not. Maybe it's welcome. I don't know. See, that's a joke. I haven't wished rape on anybody. That's a joke. Why would I have a problem with that? People. So, Willson, what happened in Willson is that the officers testified that Willson was saying things that weren't fighting words. And they had a problem with her inserting herself into the situation through words that they thought were undermining their ability to control the situation. I guess it was a guy who was like going to commit suicide or murder or suicide by cop or something like that. I don't know. I don't really care. That was kind of the situation. And they thought that her actions were interfering with that particular situation. They thought her words were interfering with that situation. And so what the Court of Appeals did is says the statute isn't overbroad. We are narrowing it down to fighting words, which is what any court would do, because that's what the Supreme Court said you basically had to do for these kind of statutes. And that court remanded it back to the trial court so that the trial court could develop whether or not the trial court could make a determination of whether or not the words that she was saying in the situation that she was saying them in to the people she was saying it to, if those were fighting words. Because remember, it might be dicta, but it's dicta that courts seem to be following out of Houston versus Hill, that cops have to be able to accept a certain amount of criticism. So maybe to a cop, it's not fighting words. Maybe to a cop, it is First Amendment protected criticism. And if it is First Amendment protected criticism, then it's not fighting words. If it's not First Amendment protected criticism, it might be fighting words. But that's something that the finder of fact would have to determine, whether or not in those circumstances, those words said to those people in that tone, in that way, at that time, if those were fighting words. Anyways, I've dragged this video out long enough. I have finished my lunch. I have a lot to do, so I'm going to take a short lunch. Have a great day.